All right, everyone, we have breaking news, which is the judge in the Rittenhouse case has tossed one of the counts pertinent to that case. Initially, there were 7 charges. One of them was tossed a couple of days ago. That was the idea of Rittenhouse violating curfew. He didn't, so that was tossed. Now, as of right before the prosecution and the defense provide their final bit of, they've got 2.5 hours apiece, provide their final bit of testimony and argument, another charge has been thrown out, which was the idea of Rittenhouse having an unlawful weapon. And it was funny because at the time, the defense said that they wanted the charge thrown out. And the state, of course, said they don't want it thrown out. But they didn't actually countermand the idea that the weapon was lawful. The judge said, oh, well, we can measure it right now. And obviously you can measure the barrel length. If it is a longer weapon, which is what Rittenhouse has, he was lawfully possessing that. It is not a short-barreled rifle, but something with a shorter barrel. Of course, that has a different aspect to it under federal law as well. And so they didn't decide to bother contesting that. Now, what's the importance of this? If Rittenhouse showing up in Kenosha, he didn't traffic weapons, we knew that a long time ago, didn't break curfew, he wasn't unlawfully possessing a weapon, what specifically drove people to attack him? The problem is that all of the charges require that he have acted negligently in deploying what he erroneously believed was his ability to defend himself. For instance, initially, in the first case, he's chased. If he was unlawfully possessing a weapon, the state could have made the argument, well, you know, this individual saw the weapon and saw that the barrel was too short and decided to subdue this individual. That never happened. Now, did it? If Rittenhouse was there lawfully, he was putting out fires, again, not violating curfew, not violating any weapons laws, supplying medical aid to other people, the idea of being able to prove that he was reckless or malevolent in some way, really, it's massively damaged. I can't imagine that they're going to find 12 people that are going to find him guilty, certainly of the more major charges. You're talking about first-degree homicide, etc., etc. There are some reckless homicide. You could theoretically say, well, you know, we think that when he was on the ground, he was basically half incapacitated and already been assaulted with a skateboard. He shouldn't have fired his weapon. He should have just hit the dude with the butt of his weapon. They could theoretically do a workaround like that. I'm not seeing any charges, though, that I think personally would stick. And if I was on the jury, and of course I'm not, possibly unfortunately, I would say, look, kid shows up. He clearly was there for the purpose that he states because he proceeded with that purpose. He did give medical aid to people. He did put out fires. That side of his story holding up. He's done nothing unlawful. He is being attacked by another individual who is being openly belligerent to him. Another individual later draws a gun on him who had also been openly belligerent. And in state testimony, one of the state's own witnesses saying Rittenhouse never did jack until he had already had a gun pointed at him. Now, what more of a clear-cut self-defense situation can you possibly need? What more of a self-defense scenario can you actually have? You have a 17-year-old fleeing from an assailant. Now, that assailant didn't have a deadly weapon at the time. The first assailant I'm talking about. The first one that was shot 4 times. He was attacked. I realize that throwing a bag at someone isn't necessarily the prime definition of assault, but you're not allowed to do that. You're pursuing another individual who has attempted to stave you off, by the way, through non-lethal means by pointing a weapon at you, continues to attempt to flee, did their duty to retreat, clearly. I mean, we've got it on 5 or 6 different versions of video. That person ends up getting shot by attacking the individual and is subdued. That individual then continues to flee. Does not, the state attempted to say, well, he ran towards, I think it was Rosenbaum at the time, the second person or third person shot. That never happened. Attempts continuing to flee, is chased by multiple individuals, one of which I guess they haven't even identified, is assaulted by several people, has a gun pointed at him. The problem is that the only reason that those second cases actually existed, the only reason Rosenbaum was shot, the only reason Rosengrutz was shot, is because of the first altercation. But the first altercation was self-defense. Now, if a person is out in public, let's say there are a couple of people fighting, and one of them ends up killing the other, but it's self-defense, and I chase them, they are, and this is something that the judge mentioned, they reasonably believe that they are stopping crime at that point because they were defending themselves. They had a reasonable belief that they were defending themselves. Here comes another assailant. At that particular moment in time, and this is what the jury has to consider, that person does not know necessarily that that assailant's not working with the other person, is not themselves a criminal or murderous or something like that. In their mind, reasonably, and this is the prime thing the jury has to consider, did Rittenhouse reasonably believe he was acting in self-defense? Most of the charges boil down to what was going on in his head at the time, and of course the jury has to pick through his actions and the testimony, and testimony by others to determine that. But if he was acting lawfully in the first place, and he was, therefore he would have a reasonable belief, and he'd said this on the stand, I didn't expect to get attacked, I didn't expect to have to use the weapon, it was just for self-defense in case it was needed. Does that individual, once they've been assaulted once, they're fleeing, if they're attacked by other people, do they not have the reasonable expectation that they should be able to defend themselves? Especially when one of those individuals had already assaulted him, in fact, technically two individuals, before he fired a shot. Well, the answer clearly is yes. With the weapons charge thrown out, I would think this should be cut and dry, and I hold fast to one thing. I think this helps his odds of being found not guilty on at least the more serious charges. I personally believe that if the jury finds him guilty at this point of anything, based on the fact that he lawfully was carrying his weapon at the time, of any charge, including any of the lesser includeds, because the weapons and the curfew charge, those are minor, those are misdemeanors. Everything else is at least a minor felony. It will be to try to stop riots. I wish that it were possible to instruct the jury, and maybe we need a constitutional amendment to address this issue, that the fact that there's intimidation, and National Guardsmen in Kenosha, 500 of them at the moment, 500 Wisconsin National Guard, and all of the political bullshit, the hubbub, and the propaganda by the legacy media, that there's no reasonable expectation that finding him guilty on a lesser charge to try to stave off the burning of Kenosha 2.0 is actually going to work. Only finding him guilty on every charge would even mitigate in any way the subsequent riots. And then there'll be celebratory looting. We've seen this before as well. You've got two scenarios here. He's found totally not guilty, I think, or by and large not guilty. And it gets a slap on the wrist technical charge, a class D felony or something. And people riot. And they do another $1 billion in damage. They show their ass and they show us exactly why Rittenhouse acted in the first place, because of violent rioting thugs. Or they throw the book at him and they still get a bunch of looting, probably to the tunes of tens of millions anyway. People be breaking into the stores to get their flat screen TVs. They won't break in the bookstore though, because that would be beyond their pay grade. Flat screen TVs and all of the other bullshit that they want. And then you'll see, ultimately at the end of the day, nothing is accomplished. A teenager is put in jail, presumably for the rest of their life, and nothing changes. Or the jury can, and I hope they do this, stand on principle, look at the case, actually look at the evidence, say if he wasn't unlawfully wielding a weapon, nobody had any reason to chase him. Nobody had any legitimate reason at any time to pursue this kid. Nobody had any legitimate reason to throw bags at him, to hurl insults at him, to threaten to kill him, actually, as I think it was Rosenkreutz who did, according to state testimony by one of their own witnesses. Nobody had a reason to impede him. And if you listen to the judge's instructions, of course, the belief that one is defending themselves against the impeding of their body and possible grave bodily harm, which I think when you're getting your head bashed in by a skateboard or having a gun pointed at you, you'd believe, nobody else ever had the right to act. So if you attempt to apply self-defense to, for instance, Rosenkreutz, who did draw a gun on an individual who in turn had just shot somebody, he doesn't get to argue self-defense because that initial individual was justified in that second shooting that he witnessed based on the first shooting that I guess he didn't witness because he was pursued, because he was attacked. It's clear-cut self-defense, and this trial goes beyond even Kenosha. It goes into the realm of, are we going to have a nation in which people can lawfully defend themselves against rioting thugs who themselves, just by their mere presence based on their behavior, is law-breaking. And Rittenhouse did not confront them, didn't even say anything to them. He was there to put out fires and give medical aid to whoever needed it, including friend and so-called foe. I guess he learned who the foes were when several of them attempted to assault him and possibly murder him. The case should be open and shut. We'll see what happens, because there is always a possibility that the jury says, well, I don't want Kenosha to burn to the ground again. Last time the rioters were here, it was pretty dicey. And then, you have this situation, you have several people killed. Well, I don't want that again. Let's just give them a lesser charge and hope that they go away. They won't go away, though. That's the whole fucking problem. That's about all. Peace out.